Earlier this year we produced a Q&A video for our landlords to help them prepare for the upcoming Renters' Rights Bill that takes effect on the 1st of May this year. This morning we've gone a step further and we've invited Alex Jeffrey, the managing partner of Bright Solicitors in Plymouth, to join us, answer questions from our landlords and give a greater insight as to what we need to be prepared for before the rules take effect on the 1st of May.
Assured short-hold tenancies will no longer have a fixed term. We understand that tenants can therefore serve notice to leave at any time, but landlords cannot serve notice for the first 12 months. What reasons are there that landlords can serve notice early to a tenant?
So the main ones I think would come across under the new post 1st of May will be in relation to rent arrears. That will be the main one. There is the ability to obviously serve grounds for antisocial behaviour. But that will need some careful record keeping, etc., which obviously yourselves will do. So there's grounds for antisocial behaviour. There are other grounds, mortgage in possession, if there's any issues there, failure of the tenant for right to rent checks, etc. as well, or if there's any fraud or anything like that on behalf of the tenant when entering, which wouldn't be picked up in the usual compliance checks at the beginning, which unfortunately sometimes happens. But the one I think we'll see mainly will be your rent arrears grounds and also antisocial behaviour, because they were the two main reasons that landlords look to evict in any event, together with the sale and move-in grounds, which we'll come on to a bit later. But they're the two main ones which we see going through the court at the moment.
Okay, and what's the earliest date a landlord can serve notice
on the tenant for
if they have antisocial behaviour?
Antisocial behaviour, you can do that instantly. There's a new ground 7A which you can do instantly, but it needs to be in quite severe circumstances, so it can't just be done sort of if there's a bit of loud music one night. You can't serve that notice. There is a discretionary ground, but my best advice, if you want it to be a successful process, i.e. serve a notice under a ground and then relying on that to evict the tenant at the end, my best advice would be to have a good detailed log of a pattern of behaviour to show it's antisocial rather than a one-off instance. So if you have a one-off instance, it's very hard in front of a judge to be saying, well, we believe this is antisocial behaviour, without a train of repeated behaviour effectively. So the more evidence you can have on those claims, the better. They aren't the easiest ones in front of a judge to prove, so unless it's really extreme examples of antisocial behaviour, they're not always the easiest to prove.
Okay, that's really helpful. So on the idea of the rent, what happens if the tenant doesn't pay their rent, and likewise with antisocial, how quickly can they be evicted?
So at the moment, under the current market conditions we have, you have a couple of ways you can evict for rent arrears. There's what's called a mandatory ground and there's what's called a discretionary ground. Ideally, before you go in for court, you always want a mandatory ground rather than discretionary ground. So at the moment, ground 8, which is for arrears, provides for a period of at least 2 months worth of arrears at the point of the service of the notice. And then there has to be, in order to get the order, 2 months at least at the point of the hearing date. Under the new regime from 1st of May, that 2 months has gone out to 3 months, so you need at least 3 months worth of arrears before you can rely on the mandatory ground. And then you would then be able to serve a 4-week notice rather than at the moment a 2-week notice. So for that bit on the rent arrears, if you were looking at evicting under that ground, you would have at least 4 months worth of arrears, unfortunately, if you rely on that mandatory ground.
Okay.
There are also discretionary grounds that you can rely on, but my advice with all landlords would be to, if you can, rely on a mandatory ground, not a discretionary ground. The discretionary grounds, when you go before a judge, it's up to the judge whether they order that possession. If you have a mandatory ground, there has to be a reason why not. So as long as you meet that criteria of 3 months to 3 months under the new regime's worth of arrears at the point of the notice and at the point of the hearing, you will get an order for possession. Whereas if you rely on the discretionary grounds, you won't have that. Okay. So you would, in those notices for rent arrears, probably be looking to put in all of the grounds, so 8, 10 and 11 is the ones which I commonly see for rent arrears, and that way you cover a full basis.
Okay. And if the tenant was to try and stay under their 3 months rent arrears and ultimately pay just to make sure they always are only in 2 months, ultimately you can't then pursue the the rent arrears or the mandatory grounds?
You on the mandatory grounds, no, but which is why I think it's really important, and I'm sure you advise your agents of this as well, to include those discretionary grounds when you're serving that Section 8 notice for rent arrears. So then it gives you the option to still proceed, albeit it has a bit of risk attached. And what the judges will usually do is give a suspended order for possession on the basis, one, the arrears are cleared, and two, they then keep up. Okay. So at that point, if you had a suspended order for possession, you would be able to then reapply to the court to say, look, they've breached the condition of the suspended possession order, please can we have a possession order. So that way, as long as you can show basically they haven't paid rent when they're meant to for a period of time, which you'd be able to show given you got to that point anyway, you would then be able to serve and then apply to the court. But the more bulletproof way would be to go for the mandatory grounds rather than just simply relying on discretionary, because there's a bit more risk with that.
Yeah, absolutely, that makes sense. Well, whilst we believe most tenants are just looking for a long-term home, is there anything to stop a tenant to move in and then leave a property every few months under the new rules?
There's nothing that you can really stop them. I think that's where having a really good agent on acting for your landlord like yourselves would be really beneficial. So when you're looking at potential candidates for properties, I think it's really important that you ask the right questions. So I think you'll be looking at, sort of location of property. Is it furnished? Is it not furnished? What are the ties of that person to the area? All those types of questions, which I'm sure you undertake as part of your sort of screening to see who's going to view it in the first place. I think they'll be the really important questions. And ultimately, I think for a landlord, they want that longevity piece with the property being let rather than short-term, high turnover, because they want the security of the rolling income as well. So I think it is going to be really important when yourselves are sort of showing people around and speaking with your landlords, is working out who is the best fit. And then obviously I presume you'll sort of put a selection forward for your landlord to then pick ultimately who they wish.
So really the best protection in that scenario is just having a good agent who really vets the people properly.
100%,
and that's how you can safeguard
100%,
yourself.
yeah.
Well, that's really good. So if a tenant offers rent in advance because they cannot pass referencing, is a landlord now legally allowed to accept this?
Up until the 1st of May they still can. Post 1st of May they can't. So there is a school of thought that they can offer a voluntary payment after the initial rent period starts, i.e. the commencement of the tenancy. But I think there's a bit of risk with that. The reason I say that is, if you look behind what the government is legislating for, they do not want rent in advance. So if you're asking if people are voluntarily paying it, it's still rent in advance, just via a different mechanism. With it being a voluntary payment as well, you cannot enforce any sort of contractual obligation on a tenant. So if they say, I will pay after the first month to try and get round the Renters' Rights Act, and they don't, there's no way which you or your landlords can enforce that. So it is almost like a trust exercise. So if you were talking about picking tenants and beforehand, if you were looking at which is the best candidate and you're thinking, well, they'll be better because they may pay rent in advance, my view is you probably want to discard that may, because there's no guarantee.
Okay.
So I think moving forward with a federal referencing, etc., there isn't an ability for rent in advance. And I think we do speak about it a bit later, but I think at that point we'd be looking towards rent protection products to try and protect their position a bit better rather than having the security of the rent effectively up front.
Yeah. So ultimately, from a landlord's point of view, as you say, we may come on to more detail, but if these people aren't passing referencing but they haven't got any other options, then rent protection is the next way to try and safeguard themselves going forward.
Yes.
Okay. For tenancies that commence within the 12 months prior to the 1st of May, which of course we're in that period now, does the 12-month protected period restart once legislation comes into law, or will the timeline be from when the tenancy actually started?
So it will be from when the tenancy started. If you've done renewals, that could arguably affect when that is. So if you have a commencement of a tenancy in 2025 and you've run out renewal, that 12 months will probably start from that renewal date. If it turns into a periodic, there's a case called superstrike, which I'm sure you've heard of yourself, which arguably creates a new tenancy structure at that point as well. So there's an argument to say whether that 12 months will run from that periodic point after that fixed term ends. There's another argument, if you want to be really legal boffin about it, is about arguably on the 1st of May, with the creation of assured periodic tenancies, what will probably happen is that is a new tenancy. However, I don't think, in my view, that is what the government are intending.
Okay.
So the 12 months will be from either the point of the tenancy agreement or that renewal, whenever that may be.
Okay. So for actually those people that have already got those tenancies started, the 1st of May, that won't affect them from that point of view to start with?
No.
Okay.
And with those notices, in terms of the 12 months protection, those are under grounds 1A under the new Renters' Rights Act. And what they're saying is you can't rely on that notice in the first 12 months of a tenancy, but you can serve the notice in month 8 to expire at the end of month 12. So hopefully that will give them, the landlords, a bit more comfort of, if the time is ticking, you still have an ability for that 8 months in to serve the notice. And at that point, obviously, if they're looking to sell, they'll probably be looking to you to assist them with the sale, so you can go in, do your appraisals in the usual way, etc. at that point.
Yeah.
And it gives you a 4-month period on the hope that the tenants vacate at the end of that notice to get people in looking around if they're looking to sell.
Yeah.
And
So that's fairly similar to what it is now, other than the fact that it's now 4 months before the end of the tenancy rather than 2.
Okay.
Okay. Well, on that note, if a landlord is considering selling their property this year, or the property is currently under offer, but they've not yet served notice to the tenants, what's your advice to them? What should they be doing at this stage?
Right now, I would be serving a Section 21 notice. They have a 6-month shelf life, Section 21 notices, from the date of the notice. So what the Renters' Rights Act does is provide a transition period of 3 months from the 1st of May in order to rely on Section 21 notices which are served prior to the 1st of May. Given where we are in sort of February now, there's no harm in serving that notice to allow for that maximum 6 months. So my advice would be, on the hope that you are going to be selling, would be to effectively serve your notice now, get that 2 months ticking, which is the usual practice for Section 21s now. And if you do, for example, have a purchase which is ready to go and the tenants aren't leaving, at least it gives you some security to apply for possession under that Section 21 notice now, rather than have to wait under the new regime and then there's a 4-month notice, and then it makes the process.
So by doing it now, we'll save them time rather than doing it at a later date.
Correct, and gives them a bit more protection in terms of the 2 months, and as long as you have all your compliance documents through, which is, you know, we've worked together in the past and never had any problems from that point of view, it is going to be an order of possession granted. So that's important, whereas under the new regime, under post 1st of May, it will all be very new for the judges, etc. So you've got a 4-month notice period, and then I think it'll be a longer period again before you'll be able to obtain possession.
So really, any landlord who's thinking of selling really should be putting that into place, serving their Section 21 at this stage.
Yeah.
And ultimately, the risk is that the property may be empty, but that's better that than actually prolong it at a later date, post 1st of May.
I think so, yeah.
Okay. Back to the actual tenancies when we're finding new tenants and understanding there's now new and fairly firm rules around discriminating against tenants. Will landlord have a choice about letting to tenants, for example, and on benefits?
Yeah, so one of the main big changes on discrimination under the Renters' Rights Act is to do with tenants with children and tenants in receipt of benefits.
Okay.
So you cannot positively discriminate against those people when you're looking to let property. And that includes not just actually you've been successful, here's your property, but that also includes at the point of saying no people with benefits, or we're not allowing you to view it because you receive benefits. So that process in terms of when that discrimination can start is a lot earlier. So I think if people aren't successful for one reason or another, your tenants, there's simple ways to say to them, you haven't been successful, but we'll bear you in mind for future properties. And also, they're the two main ones for discrimination. If the property isn't fit for purpose, if it's overcrowded, whatever it may be, that is a good valid reason to not let the property to them.
Okay.
But you cannot positively discriminate for that reason.
So actually, in the first instance, it's us as the agent that need to make sure we're not putting anything that could be considered discriminating against that tenant.
Correct, yeah.
And come that time, assuming we have multiple applications, it'll then be up to landlord to choose who they see fit.
Yeah, who's the best applicant for the property.
Absolutely. So within that, we also understand that landlords can no longer refuse pets without a valid reason. What is considered a valid reason? And without one, can tenants have a pet at any time during their tenancy?
Yeah, so the new Renters' Rights Act provides that tenants can effectively request permission to keep a pet at the property, and that request cannot be unreasonably withheld. What isn't and is reasonable will depend on the circumstances, and those circumstances will depend on the property type, so if it's detached, semi-detached, high-rise flats, whatever it may be in the country, and then also the size, the type of animal they're requesting to have. So if people are expecting to have multiple animals in a very small high-rise one-bedroom flat, then you'd probably say that isn't unreasonable to withhold that consent. The other ones which I think will be most prominent will be sort of any head lease. So if your head lease provides that no pets, that isn't unreasonable to withhold that consent for that. The other one that I think I've heard of a lot of questions about is in relation to other tenants in a building that may have allergies. So if there's other people you know of, if it's a HMO for example, who are in the property who have severe allergies to certain pets, it's not unreasonable to withhold the consent for that pet. But that's why I think it's important to understand when that request for the consent comes in, you're able to understand what animals and what the environment is, flats, houses, etc. So yes, you cannot unreasonably withhold that consent. And I think from my point of view, what people need to do is, rather than think, why shouldn't I allow them, is the starting point is they should. And it's a reason why not. So it's about sort of backwards thinking in terms of not the unreasonable why can't we, it's we will unless. So it's almost changing that mentality on that.
So it is subjective, but yeah, from the landlord's point of view, if they've got what is considered to be a house with a garden and it's perfectly adequate for pets, ultimately that's something tenants will be allowed.
Yeah.
And will tenants be able to appeal if the landlord refuses it?
Yeah, they can, and that's why I think it needs to have some good reasoning behind why you're not allowing it. Those requests, obviously, my advice to landlords I act for is they have a fully managed service now, and those requests ultimately, if you're the managing agent, which would be yourself, will be coming to you. So you would be looking in the realm and then advising your landlords on, in this situation, is it unreasonable? We don't think so, or we think it is because of this. And I think we need to be very objective about what we're trying to achieve. Is it unreasonable? If it's not, there's no point trying to find reasons to not, because the tenants will simply just appeal against that decision, and then it elongates the process even more. And there's some fines and bits and pieces which you just don't want to fall foul of for the sake of that either.
Yeah. So there's an element of having to accept the new rules unless it's unreasonable. And,
100%.
And going back to what we said earlier, having a good managing agent is probably the key to make sure that you're fielding this and we're making sure that
Makes
the right people.
the process for landlord a lot more seamless as well. So obviously you would get the request in yourselves, you would deal with what it is, animals, houses, you know the properties well, and then you'll be able to advise your landlord, in your experience, what you think. Is it yes, is it a no, and the reasons why.
Okay, yeah, that makes sense. In terms of rent reviews, I mean, we already, as a managing agent, review rents for the properties we manage once a year, and we give advice to landlords of what they can increase it to and what's reasonable. How is this process going to change? And if tenants do want to appeal against the rent increase, how long is that process likely to take?
So, under the Renters' Rights Act post 1st of May, any contractual mechanism for rent reviews falls away. So your tenancy agreements you have drafted now, if there's a mechanism that says we'll increase the rent by X amount CPI index link, whatever it may be, per year, that will fall away. And under the new regime, it will be done by way of what's called a Section 13 notice, and that notice can be served every 12 months. That notice needs to be served for rent reviews in line with what they're calling the market rate. And that market rate will obviously be dictated by what's in the market, what other people are renting for at the time, what properties are available, etc. like that. And I think it's going to be more important than ever to have, like yourselves, good agents in the local area knowing what the market is, because if you get those market reviews wrong and you serve your notice, there's an ability for the tenants to challenge in the first tier tribunal, and given they can challenge with no adverse costs, so if they challenge and they're not successful, they don't have any penalising against them, it's just a free shot basically. So if it gets wrong, it's an easy challenge for the tenant. And they just simply go to a tribunal, and then the judge or tribunal, whoever it may be sitting, will effectively say that is or isn't market rate. They will never go any higher than what you put the notice out for. And it's something really important, and I know, I'm sure you do this already, is keeping those comparators about how you've arrived at that market rate. So if they do challenge, at least you can show to the tribunal, look, this is how we arrived at that market rate. And given, unfortunately, the timings around tribunals, etc., if you serve your notice, it's a 2-month period until it's activated. So you have to wait until that period's up before that rent's charged. Tenants challenge. And there's a lot of commentary at the moment about how quickly those rent reviews, if it did go to a tribunal, will be turned around. And it could be anything from a couple of months to 6 months. At the moment, it's a bit unknown, because until we know the volume of rent reviews which are challenged, we'll never know how the tribunal is able to cope with that volume effectively. So I think it'd be really important to get the rent reviews right, at the right level, to avoid the risk of going to tribunal. The cost, if landlords need to defend it and all those things, will in some circumstances commercially be more than what the rent review may be worth in that forthcoming year.
And during that time they won't be able to charge the high rent anyway.
Correct. And then the 12-month period for which you're able to then do your next rent review is from the end of the tribunal determination date, not when you served your last notice. So then you're pushing it back further again. So it is really important, if you can, sort of get your notice right, get it agreed with your tenant, move on, rather than running that risk with tribunal.
Yeah, and luckily I think that's very similar to our current system, that we do it once a year, and we always give our landlords good advice on the market value. And I think what also we were saying is, don't be tempted to try and push it too much, because you'll probably end up with less in the long run. Fair enough.
Listen to you when you tell them it's not worth it.
To be fair, we've got very good landlords who often do listen.
Good.
So coming back to evictions, which is a hot topic for lots of landlords, no-fault evictions will be abolished, replaced by a Section 8 notice. Which reasons are valid to evict a tenant if they don't leave after the 4-month notice period? What does landlord do next?
They need to issue a claim in the county court. So once your notice is served, it has a period of which until it lapses, you can't do anything. So you have to wait for that notice period to lapse. Once it lapses, if the tenant hasn't moved out, there's an ability for landlords to apply to a county court for an order for possession, and at the moment it's fixed costs, which is effectively the court fee and a fixed element of solicitors' costs. Once you have your application in, so you put your application for possession in, your claim form, you would then get a period of time where the tenant can defend the claim. So we're seeing a lot of claims get defended now for disrepair, for example. That isn't necessarily true reflection of the state of repair of the property, but it is a mechanism of a defence. We're seeing local authorities who are unable to house people at that point when the notice expires say, don't move out, wait until the end of, or you're evicted by a bailiff, which gives the landlord no option but to apply to the county court. And then it'll be set down for a hearing, usually if it's Section 8 under the new regime, and then a judge will just review the papers and make sure everything's in order, and that being the case, you'll get an order for possession, hopefully an order for costs.
So that process is very similar to how it is currently?
Yeah, it will be,
albeit
just a new form 3A instead of a Form 3.
And the notice period is just that bit longer, as we know, to 4 months.
Yeah.
And so we also understand that landlords will be required to register on the Private Rented Sector Database, or PRS. What's the reason for this? What do landlords need to do and when?
I think what the government are trying to do is make it a more transparent market, so they want all landlords to be registered. When you look at enforcement as well, in terms of the new fines which can be levied by the local authority for breaches of the Renters' Rights Act, I think it's almost showing your good landlords that you do comply, you are doing what you need to do, you are doing your gas safeties, you are doing your EICRs, you are doing those on a regular basis and making sure they're served on the tenant. And I think ultimately that database, the portals, the ombudsman, all of those things is designed to get rid of effectively the unscrupulous landlords and retain the good ones, which I think, I'm sure your landlords, I'm sure you do as well, you want to act for the good landlords and you want to be known as being a good landlord. Yes, your clients do as well. So I think it isn't a bad thing for the private rented sector more generally.
Yeah, absolutely. And I think that's what it comes down to, is for good landlords, which I'd like to say all of ours are, that look after their properties. Actually, this is more of a formality. It's out there visually.
And there shouldn't be any problems really from their point of view, because if you're managing them for them, they're doing their compliance when they should be doing it. The only thing I would be saying is, under the new regime, if people are on let-onlys I'd probably be suggesting look at fully managed because of the new, and especially the fines, because they're so significant. You know, we're looking at thousands of pounds, and if you repeat offenders, can be fines. Not meant to scare them, but up to 40,000. So if
a lot of money.
you've got landlords who continually fail, it will soon eat into any profits they may be making. So I think if you've got landlords under that let-only service, I would be suggesting to them, or you may be looking to suggest that they do fully managed because of the extra levels of compliance, and the levels of fines are so significant. It's definitely worth doing.
There's the risk involved.
Yeah.
So for people that are let only, those landlords will be required to do it themselves, but if it's a managed property, they can rely on us as the agent to make sure it's all done. So again, another reason with the new rules why having your property managed, it just mitigates any risk against big fines and
100%.
things that come with that.
Yeah.
Well, talking about the compliance, I mean, we already guide our managed landlords to ensure they're compliant and keep them up to date with any changes. Are there any changes to the current rules our landlords should be aware of? What's the importance of making sure all this is in place ready?
I think, as I just briefly mentioned there, I think the importance of understanding what landlords need to do is mainly born out of the fact of these fines. They are significant for non-compliance, and when the 1st of May comes, the local authorities who have been geared up ready to impose these fines will be looking to do that. So I think non-compliance isn't an option moving forward. I think everyone needs to be aware of the change that's come into the tenancy structures, so you can actually get fined for, albeit accidentally, entering into an assured short-hold tenancy agreement post 1st of May, rather than the assured periodic tenancy, which will be apparent. We also need to remember on the 1st of May, all existing tenancies need to be served with the information leaflet, which can be provided by the government. There is a fine for failure to do that.
Okay.
You have a month grace period in order to serve that as well, so I'm sure you'll be speaking to your landlords about serving those and making sure they're served properly, because just putting an email if you don't have the service provisions right isn't good enough. So it's about making sure we serve those documents right at the right time as well.
Absolutely. Well, I think the overview of what we've said here is that actually for good landlords who look after their property and very compliant, actually, bar maybe a few bumps in the road, this should be too bad for them to encounter, and the Renters' Rights Bill is going to probably weed out some of those rogue landlords that haven't been doing their duties very well in the time gone by. And I think, within that risk, and of course good landlords will still have to follow these, probably the importance now of rent protection. How important do you see that for our landlords?
Yeah, so I think it is important. So obviously we're losing the ability to rent in advance. Even if you have a tenancy agreement that's created already, you can't rely on a contractual provision that asks for rent in advance midway through a period post 1st of May. So rent protection is important. It's important you get the right rent protection for you. Obviously, if you've got a broker that's dealing with it, or if you have a CRM system, I'm sure you're able to recommend people as well.
Absolutely.
It is really important that you get that in place if you are unsure, because if the periods of unpaid rent are going to increase, i.e. before you can get vacant possession, we talked about 2 months to 3 months for the notice period, 2 months to 3 months in terms of the period needs to be shown for the mandatory ground, and also the 2 to 4 weeks for the notice period. There is a significant lapse of time before you're able to get possession, so it is important you get it. And I think if landlords don't have it, they should be speaking to you about how they could potentially explore that.
Yeah, and I think it's important just to recap that. So the notice to actually evict a tenant is going from 2 to 4 months, and the rent arrears moment in which you can serve them notice is now 3 rather than 2.
Correct.
So actually that rent protection, that time, especially if you're then going to the court, it could be a long time that you don't see any rent for.
Yeah, because we're seeing court claims even once we've issued, so you got your 4 months up, should we call it, by the time you've notice expired. If you have a solicitor draft your case, you say if you're into court for 5 months. We've had cases that can take 2 to 3 months before you see a judge, especially in some of the bigger cities. And then also, it's when the tenants don't leave. Appointing that bailiff is another period of time again. So
And cost,
yeah, of the unpaid rent period is time of them remaining in occupation. So we've got properties in London which we've had well over a year of unpaid rent.
Yeah, and I suppose that's your area. I mean, you're here to tell us a bit more about this, but in the hopefully unlikely scenario our landlords do need assistance, it's eventually us referring them to you and you guide them through that process.
Yeah, and I think the main thing for me is hopefully they would never need to speak to me. Hopefully they can all go through you, the properties will be managed, you serve the notices when you need to serve them, the tenants vacate. You serve your notices for rent increases and all those things at the right time. And as I said, hopefully you will never need to speak to me as a landlord. On the odd occasion they do, obviously we'll be delighted to assist them. And it'll just be a case of getting the paperwork from you, like we've worked together in the past, and running the claim through the court as quickly as possible.
Yeah. Excellent. There's one other point skipping further ahead, which is regarding energy performance certificates, and a few of our landlords have asked us about this. Now, we understand the government plan to take the minimum EPC rating from an E to a C by 2030. What do landlords need to be doing to meet that requirement? And if they have a property that simply can't achieve a C, what happens next?
I think I need to review. The legislation is still in its early form. I think until we have some more clearer guidance, it's a bit unknown. But if you have properties which are significantly lower than that rating, they may want to look at ways to increase that. There's a threshold of which the government expects you to try and reach that, and once that is at that, there's an exemption that you can apply for to say, look, we've tried our best, but it's never going to meet it. Which I think at that point that would be for landlords to do on a case-by-case basis. But I think if you're reviewing your stock generally, if you're a portfolio landlord, reviewing your stock, see what's in it. If you think, well, actually we're never going to get that one to a point of being an EPC that's needed, do you look to move that property on and invest in a newer property, for example, to then boost your portfolio in that way? Because what you don't want to be doing is pouring in a lot of money into renovation works to increase the EPC but not get the value back at the end. So I think from my point of view, we're seeing landlords do a bit of both really. We're seeing some of them get rid of their older stock thinking we're never going to get it out, and then we're seeing people who are investing now go for newer stock. So the new build market is quite popular for landlords at the minute.
Yeah. So landlords come to a bit of a crossroads in terms of, it's from this moment on, thinking about how they can increase APC ratings is a good idea. If they've got something that they'd have to invest a huge sums of money to try and get it up, they might think about what to do with that property in the next 4 years.
I think so, yeah.
And change to something more modern.
Because some things will never get there.
Yeah, and that's good for them to bear in mind. I appreciate it's sort of still in motion and early days to make that decision, but it's helpful for those landlords to know ahead of time.
Just to think about your portfolio, especially if you've got a larger one, and speaking with you about, what do you think? Can we get it there? Can we not? What's the market like for it? Can we get it gone? If we can, is it wise to do it? What else have you got on the market that we could replace it with, and all those things as well?
Yeah, right. So I think we've covered some really good points, and I think what certainly I've taken away from this is that our landlords and certainly what we call our good landlords shouldn't be too worried, but actually planning ahead. If you're thinking of selling your property, think about doing something about that now. And if you're keeping your properties, probably engage with someone like ourselves as a good managing agent to take care and mitigate these risks, and have sort of fail-safes, backup plans like rent protection, and actually, bar a few, as I say, bumps in the road, actually, hopefully a lot of our landlords won't feel the difference of the renters' rights bill.
100%. And as I said, if people are using let-only services, get on fully managed is my advice. Get the advice you need early. Don't wait until the implementation to come. Get that advice early. Get on a fully managed product.
And we can offer our landlords the rent protection as well, so that's something that we can push out to them. I'm sure when they see this video, they'll be eager to speak to us about it anyway.
That's great, it is really important.
Yeah. Fantastic. Well, thank you very much.
Thank you for taking the time to watch our video this morning. Hopefully the discussion I had with Alex gave you a better idea of what to be ready for the Renters' Rights Bill. I think it's fair to say it's not as scary as people think it is, and with the help of us as your managing agent, we'll guide you through the way and put things in place to make sure that the transition is smooth and doesn't cause you any more headaches. Please get in touch with us discussing moving from let only to managed if that's relevant, or putting in place rent protection. Whatever your query is, come speak to us and we'll be pleased to help.